Hey folks, I'm attorney Roger P. Foley. I'm going to get right to it. I recently had a case and these were the facts. I'm going to read right from the police report. All right. On 12/15/2022, at approximately 6 o'clock, I responded to the Palm Beach Gardens Mall in reference to a retail theft. I made contact with Sergeant Smith, who had two suspects in custody for possible shoplifting. Sergeant Smith had the white male in handcuffs, and I handcuffed the white female who may also be involved. See Sergeant Smith's supplement for further information. The white female was identified as Sheila R., and the white male was identified as Cliff B. I made contact with the subject who stopped Sheila and Cliff. That was a white male named JC, and he's an employee of Apple. JC stated that he received a phone call from the store manager, a Hispanic female named Olga. Olga advised that Sheila and Cliff had attempted to take some earbuds and some other Apple products from the store, but she spooked them and they left. JC said she told him to keep an eye out for them, and he did. JC saw Sheila and Cliff and flagged down Sergeant Smith about the possible theft. JC said after the white male was detained that he observed two pairs of Apple devices inside the white shopping bag that Cliff was holding. JC then called Olga to verify if the Apple products came from the same store. I, the officer who wrote this, then spoke with Olga at Apple. Olga advised that the Apple products did not come from the Apple store, but came from another Apple store in South Florida. Olga advised that she would return the products to that Apple store. I then spoke with a black female. Her name is Latoya Jackson. She works at the South Florida Apple store, and she advised that she was unaware of the retail theft until Olga contacted her and returned the Apple products. Miss Jackson stated she scanned the products and that Olga returned, and no purchase had been made with those specific products. She further stated that there had been no sales of those products in that store during the day. She provided a sworn video statement. She provided for the cost of the two products that were approximately $2,000. And I'm sorry, the three products, because there was another Apple product in there, sorry. And she advised that they must have been taken from the display that's in the Apple store. I photographed the merchandise. I then went to the South Florida Apple store and I reviewed the video that was given by loss prevention, and I saw Sheila and Cliff on camera at that store, and I saw Cliff select the three items on the display, conceal them inside a shopping bag, and then select another item and put it also inside the bag. He was standing there, and the girl Sheila was standing there, and she didn't she didn't take part in the theft. Cliff passed all points of pay, and I recorded the video and got a copy of it. Miranda was read, and Cliff declined to speak with police. All right, folks, so you want to know the down and dirty, right? You want to know the down and dirty. So I'm gonna break down the down and dirty for you. All right? How does an attorney, right? Two people are caught, one is let go, one is arrested, right? The charge is grand theft, right? It's retail theft, but because the amount is over $750, it's $2,000 or so. It's a grand theft, right? So I'm gonna kind of walk you through how I analyzed it here. And give me a second. I made some notes and of what I did. Okay. Let me do this. All right. So I look at the case and I go, all right, only thing I have to go on is the probable cause affidavit, right? What the police officer wrote. And that's all I got. So Sergeant Smith has two suspects in custody. I take custody to not being detained. I take custody to mean that they've been arrested. I'm using the words of the probable cause affidavit. All right? So, the second employee, the hell is his name again? JC. So, JC is an employee of Apple, and he says to the police that Miss Olga, the store manager, told him that the defendant had attempted to take some items from the Apple display, but that she spooked them. So arguably, my argument is she didn't see the defendant steal anything. And she did not see anything missing because she would have said he walked away and there were products missing. She didn't say that. So my argument becomes there's no probable cause for the stop of the defendant and his female friend. Now, the stop should not have happened, and these are my exact words, just so you know, because I'm right. The stop should not have happened because her own words were that she spooked them. Acting suspicious is one thing, attempting to steal is another. The Sergeant Smith, he stopped them without speaking to her. When I say her, I mean Olga, the manager, because she's the one that told, right, JC, hey, be on the lookout, right? They didn't even speak to her. So this is hearsay that they're getting it. After the defendant's detention, everything is discovered. Now they say that it was in the bag. It was allegedly in the bag. Well, was that bag opened, right? Did JC go into the bag? Did he see into the bag? Did the cop grab the bag? Was the bag opened? How did they see the Apple products in the bag? That's my argument. Somehow they see the contents inside the bag. Even if they did see the computer items or the Apple products in the bag without opening, what evidence does the sergeant have? What evidence that those items are stolen? She already said she spooked them and nothing was missing. So, the cops check with the first employee, right? Now they speak to Olga herself. And they continue to hold the suspects. I'm arguing because he said they were in custody, that they had been arrested. They're arrested and they check the cameras at another store. So you can imagine the length of detention here, right? Because they're saying that they're being detained. I'm saying that they're in custody, meaning they're arrested. So they then go through the other cameras at a South Florida Apple. They see the defendant and the female that's along with him. They see the defendant, the white male, put the products into his bag. What's my argument? The stop is bad. Sure, they got the guy. They got it right. The guy who committed the crime, they got him. But they did it wrong. They cheated. It's the fruit of the poisonous tree. The stop should have never have happened. They should have observed. They should have waited. They could have had a consensual encounter. They could have said, "Hey, what are you doing?" They could have asked them some questions "Hey, do you have a receipt for the items that you bought today?" And they would have been free to say, "No, screw you, officer." But they didn't. The sergeant overtook them. He handcuffed them. They were not free to go. It was an investigatory stop. So what did I argue? That the stop was bad. Contacted the state attorney's office. Case dismissed. That's the process, folks. You have to analyze each and every word in a police report. You wonder how a defense attorney gets a victory. This is how. I'm not bragging. Hey, I'm good at my job. I'm pretty sure everybody would agree with that. And when I say everyone who deals with me on a regular basis, I think I'm a good attorney. I work hard. I look at facts and I analyze things. So that's it. Case is gone. I spoke to the state attorney's office, and they agreed with my logic, and the defendant walks. Not because he was innocent, not because because he's a nice guy or a great person. No. He won because the police made a mistake. And we hold police officers to a standard. And that standard is important because when the truly innocent person comes along, if I've had tens or hundreds of these cases where I look for technical arguments and I break the case up and I dissect it, it gives me the ability as a defense attorney to help that innocent person, to help that person that's falsely charged. This guy wasn't falsely charged. He's guilty of sin. But he got off because the police made a mistake. What do you think? Are you that innocent person? I'm attorney Roger P. Foley. Thanks for listening. Peace. If you didn't know, now you know.